Good morning, everybody. Thank you for having me here this morning, and I hope you find this interesting, and I'm hoping that you'll learn something out of this. I know some of these issues that I'm going to address may be difficult. I certainly understand that the first time I had to deal with some of these issues in my practice, it's hard to get your head around it. I'm hoping by the time we're done here this morning that you'll have kind of like a base understanding of some of the duties I'm talking about. And also I'm going to be going through what we call case law. That's decisions decided by various judges and courts, hopefully to give you an understanding about what it actually means in practice and how to put it into practice. A little bit of background on myself. I was born in Manitoba, and that's where my family is from originally. A small community north of Winnipeg. If you've ever been in Manitoba, there's a small community north of Winnipeg called Selkirk. It's what they call on the mouth of the Red River, where it's basically the Red River flows into Lake Manitoba. That's where I was born. That's where my family was born. But eventually we moved to Kenora in the 70s. So I've lived most of my life, certainly all of my adult life, in northwestern Ontario. But I've been in Thunder Bay now since the 90s. Basically, when I finished law school, came to Thunder Bay on a one-year job, and liked it enough that I stayed here. So here I am 30 plus years later. And I certainly do enjoy it, and we can walk outside and see why we enjoy this part of the country. I always brag, when people say, "Where do you live?" and I say, "Well, I live in God's country." It's right on the tip of Lake Superior, on Canadian Shield. We've got access to everything. I remember when you're graduating law school, you've got the option essentially of going to work almost anywhere in the country. You have to do what's called an articling period, and that's where your 1-year contract comes in, but you can do that any community, any province right across the country. My brother had already been in Thunder Bay for a while at that point in time, and he was kind of trying to persuade me to come to Thunder Bay. But I remember one of the comments he made. He said, "Well, and he was big into hunting and fishing, and he still was. But his comment back then is, you can be in Thunder Bay, literally right downtown like we are right now, get in your car, drive 20 minutes, half an hour, almost any direction, and you're into nothingness. You're just into, if you want a lake, if you want a river, if you want a bush, et cetera. You could go almost any direction and you're there." And again, because he was a big hunter and fisher, he talked about like the different things he could hunt and fish, again, half an hour outside of the city type of stuff. And so it really gave you a good balance between being in an urban center like Thunder Bay that offers an awful lot of conveniences and access to an awful lot of things you need in your life. But at the same time, if you want to get away from the city, it's very easy to get away from the city, and again, it's such beautiful countryside. I'll finish off with one other anecdote, and this is from my experience when I was in law school. So, when we're finishing law school, you're talking to your classmates, where are you going? Because again, we can all come from our various communities and go back to our home communities or go back to almost anywhere in the country. So we're all talking about, where are you going to be going? And I said, "Well, I'm going to Thunder Bay." And so one of my classmates pipes up and he says, "Oh, that's they're talking from, Toronto-centric personality. Well, that's in Northern Ontario." And I said, "Well, no, Northwestern Ontario." And he said, "Well, that's close to Quetico Park." Well, kind of, a couple hours away. And then he says, "Oh my God, Quetico Park, like that's the world's most beautiful park." And I said, "Have you ever been there?" And at that point in time, I think I'd been there just to visit at one point in time. And he just talks on and on about what a fantastic park, the scenery and stuff like that, and have you gone camping there or canoeing there and stuff like that? And I said, no, never. And he says, "Oh my God, why not?" He goes. And I said, "Why would I go to Quetico?" "Oh, it's the world's most beautiful park." I said, "Yeah, but that's all of Northwestern Ontario. That's our backyards, And I really like, when I grew up as a kid in Kenora, like I lived on what was a creek, so like in the winter my snow machine was in my backyard, and in the winter my boat was tied up to the back of my house. That's what you grow up with in this part of of the country, but certainly in northwestern Ontario. So I kind of learned through that a little bit, sometimes an appreciation of what we have, because you get to look at it through somebody else's eyes rather than looking at it through your eyes. And things you kind of get used to, you take advantage of it because you see it again and again, especially if you've grown up in this area. You sometimes just see things the way you got used to it. But when you talk to somebody who's from a different part of the country or the province, and they see how much of a jewel it is that we have in this area, whether or not it's Thunder Bay, whether or not it's the immediate area, whether or not it's northwestern Ontario, or frankly northern Ontario, I've certainly grown to appreciate. And having lived in Manitoba originally, learned to appreciate, what the Canadian Shield offers. Again, whether or not it's terrain, and we can complain about the terrain. When we're driving in the winter, we'll complain about it, curse and swear about it a little bit. But during the summer, it's fantastic, And again, compared to other provinces, like I've lived in Manitoba and traveled and worked in Saskatchewan, Alberta, like they are truly the poor cousins compared to this part of the country. They just don't have the diversity. They don't have the health of the wilderness and the trees and the variety and so forth and so on. So enough gabbing, I guess. Let's move on. Yep.
We're going to come and help you.
Move over about a foot.
Okay.
We're afraid you're going to fall.
Oh.
Yeah, we can't concentrate. And I don't have to run and catch you. Yeah.
That's okay. You're covered by WSIB, aren't you? I'm looking to retire early. Maybe it was somewhat intentional. Health and safety. Bah humbug, eh? So let's move on here. So like I say, I'm going to talk about this concept of called fiduciary duties. Now, if you went through this process with us last year, you might have learned a little bit about it last year. But really, when you think about it, it may be a new concept to you, or a new word, or even, frankly, a weird word to you. And what it is you're not going to be able to pick up a piece of legislation somewhere. Like depending on where you work and the governance of your organization and whether or not you're sitting on chief and council, you may be governed by federal legislation, say the Indian Act or the Canada Labour Code, provincial legislation. You can't pick up a piece of legislation and look up fiduciary duty, and it's not going to tell you what that is. Because what it is, fundamentally, it's what we call judge-made law. And what that means by judge-made law is that it's developed over the years, frankly, over the decades, by what judges are deciding is the law and how it grows. And for some of you, depending on what your history is and your experience with your communities and stuff like that, you may be fully aware of what a fiduciary duty is, because that is the essence of the relationship between a community and the federal government. That is what imposes duties and, frankly, liabilities on the federal government, because the federal government, Canada, is in a fiduciary relationship with all of your communities. So it's an incredibly important concept, because that's actually what's developed a lot of the law over the decades between various communities and Canada. And frankly, when you talk about liabilities in terms of financial liability, more often than not, it's the basis of a financial liability between a community and Canada, or if it's a flooding dealing with hydro, for example, or relocation of a community, more often than not, fiduciary is at the heart of that relationship. So like I say, you're not going to find it through going up to heaven forbid you have a statute book somewhere. You're not going to find it that easily. But having been developed by judges as the common law, it also means that it can change over time. One of the beauties, or sometimes the disadvantages of the common law, is that a judge can actually reinterpret it or apply it into a different set of circumstances. So that's what keeps people like me in business. That's what keeps lawyers in business, because what might have been a fiduciary duty 5 years ago, 10 years ago, 20 years ago might change over time. So when there's an allegation that somebody is a fiduciary, or they've breached their duty and stuff like that, that's where we come in and we have to look at, well, what's the judges saying about that these days? How is the law changed, or how is it applying to different factual circumstances? from my point of view, again, as a lawyer, it's really beyond dispute that fiduciary concept and fiduciary duties apply to a chief and counsel. That's, as a question of law, that's certain. You know, it's not really a question of does it apply sometimes to chief and counsel, does it not apply to some communities? No, it applies to all communities, it applies to all elected representatives of the communities. Now, the fiduciary concept sometimes will apply in certain areas some part of the time. You know, so as an example, I'm a lawyer, you know, other professionals, accountants, for example, engineers, they'll be a fiduciary duty in certain situations. There's also this application of the fiduciary concept to basically the role that a person is in. And so chief and counsel falls into that category. As soon as they get elected, as soon as they kind of put on that cloak of being an elected official as a chief or as a council member, that cloak or that jacket they put on as a elected representative includes that concept that they are a fiduciary to their community. And so somebody can't be an elected official and then put up their hand and say, well, I don't want to take on that responsibility. I don't want to take that fiduciary duty. It's not an optional. It exists because you're an elected representative. And that also means that we use the concept sometimes in law that you can't contract out of it. So you can't be an elected chief or a council member and go to the community and say, well, I don't want those duties imposed on me. Give me a resolution or enter in a contract saying I'm no longer a fiduciary and I no longer have those duties. That's a complete non-starter. You can't do that as an elected official. If you're an elected official, you're a fiduciary. If you're a fiduciary, you have those duties. And there's some very basic concepts that you can think of that hopefully will resonate with you, you know, not as a lawyer like it does to me, but as a non-lawyer or as an elected official. There's some very basic concepts that hopefully you can put into practice and gain an understanding of fiduciary duties. Because in my view, is that if you have a great understanding of your duties as a fiduciary, it's going to lead into all of this governance model. Because if you fulfill your duties as a fiduciary, that means you've got an enhanced level of governance. That means you're doing your duties as an elected official. So this first comment up here, I kind of paraphrase it out of some legislation, but the nature of the duty is one person, which generally what we're talking about elected officials, undertakes to act in relation to a particular matter in the interest of another, has been entrusted with a power or discretion to affect the other's interests, and the other is in a position of vulnerability. So that's the basic concept of a fiduciary. So apply that to a community. Apply that to the elected officials. So one person undertakes to act. That's the elected official, chief or a member of council. In relation to a particular matter in the interest of another, that's your community members. That's the entire community entrusted with a power. Well, we know chief and council have powers, either granted, if you're a statutory election under the Indian Act, whether or not it's a custom election, you're granted authority to act, and you have the discretion of how you're going to act, and you can affect the interests of the community. And the community is vulnerable, either as a group or as individuals. So this concept of a fiduciary applies very, very well to the relationship between elected officials and the community members, which is why, fundamentally, if in fact you are an elected official, you become automatically a fiduciary. It's not an option, it's not a switch you can turn off and on, but once you're elected, you're automatically a fiduciary. Some basic ideas of what that means. So it's owed by each member of chief and council. And what I mean by that yes, if as an example, you have a 7-member council, yes, there's a group there, but that duty is owed by each individual. It's not a duty owed by the group, and it's not satisfied by the group. It is by each individual. So if there's, so you can, which means the group can act properly, but you can have an individual breach their duty. And so an individual can be liable because he or she breached their duty. Or the entire group can breach their duty, and the entire group as individuals are liable. And when I talk about liability, we are talking dollars and cents. So you'll see in some of the cases that if there's a lawsuit of some kind, and if there's an allegation of a breach of the duty, it's not the band who are liable, it's not the community that's liable, it's not the chief and council as a group that's liable, it's each individual member who are on council. Which also means if there's a lawsuit, each individual is hiring a lawyer to defend themselves because they're defending their personal liability. They're not defending the interests of the organization, the community, chief and council, they're defending themselves, which means if they get sued for a breach of fiduciary duty, you're paying legal fees out of your own pocket because you're protecting your own personal interest at that point in time, or defending your own personal interest, defending your decisions, which again is a lot different than if it's a claim against the community. Because the irony here is, in a situation where there's an allegation of breach of fiduciary, regardless of who is suing who, because quite often it might be a community member or a group of community members who are bringing some kind of a court action against a council member, fundamentally, it is the community bringing a lawsuit against an individual member of council. And if the individual member of council has breached their duty and are liable, that financial compensation goes back to the community. And you'll see some examples later on this morning. So again, at risk of overemphasizing it, it's a duty of each individual member of council, and a breach of that duty attracts their personal liability. When we talk about fiduciary duties, we're also talking about who's a beneficiary. And the beneficiary is, and again, we're not talking individuals here, but it's beneficiaries. The beneficiaries of that duty is the community as a whole, as a group. Not a faction, not a group. It is the entire community as a whole, which also means, getting back to the point of how you fulfill your duties, if you carry out your duties with the idea that you're trying to satisfy the needs of an individual or even a group of individuals, you've got to be careful, because there's a risk that if you're focusing on an individual or a group of individuals, that potentially is a breach again of your fiduciary duties if it's at the expense of the broader community. So again, you just got to understand, again, the beneficiaries is the community, and your duties are to the community as a whole. And as I just mentioned, maybe overemphasize it, it's personal liability of individuals. And where it comes in is that, sometimes, and again, you'll see in the examples we'll talk about later on this morning, sometimes the individual has breached his or her duty and they've actually financially benefited from that. So a more classic example of a breach of fiduciary, and it's not necessarily a governance issue, but I think it'll be an easier example for you to get your head around, is think of the idea that, you have chief and council, they're debating whether or not they're going to award a contract for certain services or products to be purchased by the community. And one of the council members has an interest in that contract. So let's say it's snowplow services, just as an example. And the council member wants that snowplow contract. And he or she sits on council and lobbies to get that snowplow contract. And the snowplow contract is awarded to the council member. Clear breach of fiduciary duties. And if somebody were to sue that council member, the money for that contract could be forced to be paid back to the community. So that's a financial gain by that council member at the cost of the community, because the community paid for that snow clearing. And if somebody were to allege liability and create liability, that individual council member breached his or her duty by participating in that decision making. And that little example starts to tell you some of the, I'll call it the practical sides of dealing with fiduciary duties. That is, if you have a financial interest in an issue, you don't participate in that decision making. You don't lobby, you don't debate, you don't even attend the meeting. And we'll see more examples of that a little bit later today. But you also see, and this is probably sometimes where the rule gets a little bit harsh, is that even if the council member does not financially benefit, but if they've caused a loss to the First Nation, if that individual has breached his or her duty, didn't financially benefit, no dollars go into his or her pocket, but there's actually a cost or a loss to the community, that council member can be actually required to pay that financial loss to the community. Which means money coming out of your pocket. You didn't gain anything, so it's not a question of saying, oh, I got a contract and I made $1,000, so therefore I pay $1,000 back. No, you may not have gained anything at all, but the community lost $1,000, that council member has to pay $1,000, despite not getting any gain. So some of the duties here, again, this is how the judges interpret it, and what they say is the duty in a given set of circumstances. They call it utmost good faith. Now, what that means in practice, good faith means, not lobbying behind the scenes, for example, so that somebody gets that you get that snowplow contract. Being honest, sharing information. Have to act at all times in the best interest of the community. Act honestly and faithfully at all points in time. And these concepts, again, it's not unique to the governance structure of your community. It's the same concepts that apply to any fiduciary in any situation. So you go out and hire a lawyer, pretty good chance they're a fiduciary to you. You go out and hire a financial planner, get financial advice, either individually or for the community. Pretty good chance there's a fiduciary obligation that applies in those situations. A lot of these are probably sitting on boards of different profit and for-profit organizations. Board members are fiduciaries to the shareholders of that corporation. So the concept of a fiduciary is not unique, it's not new, and it has been applied in many, many situations, and will continue to be applied in many situations. What does it mean? Again, just some very simple basic rules here. Not take any profit, excuse me, or opportunities of the First Nation. Some of the case law we'll talk about both in communities, First Nation governance, but also in other more commercial contexts and stuff like that. Somebody learns about a business opportunity, and they take advantage of that personally when it should have been a business opportunity that was shared with the organization. That's taking a profit at the expense of the community or the organization that you sit on. If it's a breach of your fiduciary duty, there's a risk of personal liability. Not act in a conflict of interest. Now, the concept of a conflict of interest, I think most of us are aware of that, of the concept and sometimes the rules of what is a conflict of interest. That's embedded. That's almost like one of the foundations of fiduciary duty. And so, again, we've probably seen what a conflict of interest, you have a potential or actual conflict of interest, you have to declare your interest, you have to excuse yourself from the decision making, et cetera, et cetera. That's what we see in the concept of fiduciary duty and a conflict of interest. And again, as I mentioned before, this other point, you can't contract out of the duties. You might be able to modify it, frankly, by enhancing it, but you can't reduce your liability by some kind of an agreement with the community. Now, the conflict of interest, again, that most of us are probably familiar with, is a little bit different, but also very, very similar to what you might have understood. You know, most of your organizations, again, whether or not it's your community, or if you're sitting on a board, you know, of a charity or a nonprofit or for-profit venture, there's usually documents in there, policies, for example, or even bylaws talking about a conflict of interest. Again, it's the same kind of basic concept we have here. And although the conflict of interest issue, like I say, is embedded in the concept of a fiduciary duty, it can be modified by the organization, by your community, you know. And it can also be modified by past practice. Now, what that means is that it doesn't mean that you can avoid your liability. If you breach conflict of interest, there's a risk of liability. But what would be a conflict in a given set of circumstances may change a little bit. You know, so one of the unique ways that a judge interprets fiduciary and a conflict of interest to First Nation communities is they recognize that the smaller the community, the greater likelihood there's actually going to be what I would call an inherent conflict of interest. You know, you sit you're an elected official, pretty good chance you've got family members, siblings, parents, grandparents, children that are also sitting on the council at the same time with you. Or that you're dealing with issues in the community where there's going to be a financial benefit to a close or an extended family member. And so the case law recognizes that those kinds of family relationships that might be a conflict and making a decision based upon that conflict would be a breach of a fiduciary duty in a non-First Nation context. It's less than a little bit. It's recognized that there will be decisions that you have to make as the governing body where there's actually a potential benefit to a family member. So the rules will be loosened a little bit in that situation. But again, I've seen enough bylaws and policies of communities over the years that quite often the community will actually define what family relationship is a conflict of interest. And that is a very good idea to have that defined in something like a policy or a bylaw. As I've mentioned, it could also arise from business relationships. You know, so in a situation where you're selling or your services or products to the community or a family member, or in a more classic example, employment. But it's not unusual that elected representatives, in addition to potentially getting honoraria as an elected official, they might be providing services, they might be providing products to the community, or they might actually even be in an employment relationship. You have to distinguish between those different kinds of relationships and appreciate when, as an elected official, you can make a decision on those issues and when you cannot make a decision on those issues. So I'm now going to go into a bunch of cases. So I've kind of put in some basic headlines here that kind of touch upon, you know, a duty or a breach of a duty or how to respond to a potential breach. So this one has to do with personal benefits. And this is a decision, you know, despite the fact that it's from 1992, it's still very much relevant. And so at that point in time, when she was still elected as a chief, she had, excuse me, she had caused the chief and council to issue payment. First of all, over several years, her children were going to a private school and caused chief and council and administration to pay for the private school tuition for her children, caused the band to repay a student loan on her own personal behalf, and then caused the band to refurbish and build a home for herself. And so once, and this often does happen, Once they're no longer out of office, somebody gets a look at the books and they find out that something was a bit questionable. So now she gets sued after she's been out of office. And the basic question in that is that, you know, when she got the money, you know, on behalf of her children, when she got the money on behalf of her student loan, and when she got the home, what did she breach her fiduciary duty at that point in time? And what's inferred out of the case is that, you know, the chief probably wasn't aware of the whole concept of fiduciary duty. She probably breached those duties, actually not being aware of those duties. But that didn't make any difference to the court. So the court comes back, and this is a quote right out of the case, and said, no question, you know, eliminate any doubt in your mind, no question that a duly elected chief, as well as the members of a band council, are fiduciaries. So that's a hard rule. If the law is ever black and white, that's a situation where the law is black and white. Upon being elected, members of the band, they have to act in the interest of the members of the band, and the members of the band are vulnerable. A fiduciary undertakes not to allow his or her interest to conflict with the duty that he or she has undertaken. And I emphasize conflict. You know, so it's based upon, you know, it's one of the pillars is avoiding a conflict of interest. Then the court goes on, the chief or a council member, a fiduciary shall not enter into a transaction in which she has a personal interest. So right away, I hope you've learned enough already, red flags are flying. She benefited by having the band pay for the tuition for her children to go to private school. That's a red flag. She had the band pay for her student loan, direct personal benefit to her. She got a home, direct personal benefit to her. So I call those red flags in the context, they may be completely fine. Maybe the community can actually do all of that, but then the question is, what was her role in all of that? It does not matter whether or not the fiduciary acted in good faith. Any gain or advantage must be considered as accruing to the principal. That is the community members. And this is the important point. This is where she crosses the line, you know. So the fact that she personally benefited doesn't mean by itself she breached her duties. But then she crosses the line. She could not have lawfully participated in decisions of the band council which involved her interests. So if she participated in a decision to have her tuition for her children paid, if she participates in the decision to actually have the housing allocated to her, if she participates in the decision to actually have her student loan paid by the community, it's a function of that personal benefit, and then on the other hand, she actually participated in the decision. Her duty as a fiduciary was not to participate. Again, black and white rule there, hard rule. Don't participate in a decision when you personally benefit. And then, like I say here, the court was commenting that she probably didn't know she was a fiduciary, probably didn't know what her duties were. Her lack of knowledge is irrelevant to her potential liability. She can't plead ignorance and say, oh, I didn't do it intentionally, I didn't know any better. That's not an explanation. At the end of the day, had to pay back the student loan. She had to pay the difference between what the children would have otherwise received, because again, there's allocation for education funding. She had to pay back the difference, which added up to like about over $50,000. And she had to pay damages for the use of the home. By the time the court made the decision, the chief had returned the home back to the community. So she didn't actually have to pay for the home at that point in time, but she had to pay compensation for getting to use the home while she was in breach of her fiduciary duty. She tried to argue that there actually was a band council resolution authorizing all of these payments. And again, this is where it gets important again. It's not a defense, either A, when she actually participates, or when she didn't actually make full disclosure. So if the chief has information that would influence the decision making, the chief or the council member has an obligation to actually share that information. And so getting back to the tuition for her children as an example, yes, the community would pay for tuition for a child to go to school. not 10 times the amount that she was asking for. So she had an obligation not to tell the rest of the council members, oh, the community pays for children to go to school. My children are no different, so therefore pay for my children to go to school. That's a bit of a misrepresentation, because if the community pays, as an example, $2,000 a year, and she actually wants $10,000 a year, that's the information she has to share with them. Because it may not be in dispute that the community pays for the children to go to school, but what's in dispute is the amount. And she didn't share that information with the community, and hence that ended up being a breach. And so like I was saying earlier on, like although this was the liability of the chief and stuff like that, the whole lawsuit was actually started by several band members. And this is fairly common, that after somebody has left office or after information becomes public, it could be a council member, it could be a former council member, or it could just be a community member. They essentially bring a lawsuit on behalf of the entire community to try and recover that money from the outgoing member of council. And so although it might be a bunch of individuals as community members who start the lawsuit, the money ends up going back to the community anyways. So somebody can't bring the lawsuit and personally benefit from that. This ended up not actually having a direct impact on her liability, but I put this comment in here is that there was in fact a lot of hostility. Again, sometimes band politics can be pretty nasty sometimes. So there was in fact this element of hostility between the incoming and the outgoing chief and council. And this tells you how far they're willing to go. Outgoing chief and council, they were voted out, and before the power had changed hands, they literally fired everybody, cut off, and this was I think in November, cut off the heat, cut off the hydro, and cut off the telephone, and then fired everybody. Well, at the band office, yeah, but Now I put that in there, although like I say, that wasn't considered to be a breach of fiduciary. I would argue that is a breach of their fiduciary, but it wasn't one of the reasons why there was a lawsuit there. But the judge made comment on this. And I think this is important because a lot of what a judge does when looking at a fiduciary duty, looking at the facts, and determining whether or not there was a breach and whether or not there's a liability, a fair bit of it falls within the discretion of the judge. And if the judge sees something like this, how do you think the judge is going to exercise his or her discretion? Are they going to exercise their discretion in favor of the chief or against the chief? This is the kind of stuff that would influence the judge to exercise his or her discretion against the chief. And there's a concept that we use called clean hands. So sometimes when a judge actually has discretion to order a remedy, we call it, the technical expression is in equity, they look at, does the person who's being sued, namely the chief, come in with clean hands, or the people who are doing the suing, do they have clean hands? This is really dirty hands. They're going to exercise their discretion against the chief. And so I just raise that as a point that if you're in a position of being chief and counsel, sometimes if somebody's being accused of wrongdoing or you breach your fiduciary duty, it's a normal human reaction, unfortunately an emotional reaction, you double down. It says, well, you sue me, I'm going to sue you. Or you're going to sue me, then I'm going to cut off your housing funding. I'm going to kick you out of your house. That's getting this area of dirty hands. If you're an elected official, I just encourage you, don't go down that path. And then the court just emphasized, fundamentally, absolutely have to act in the best interest of the members of the community. So in this one, again, this is a decision from 2002. It's a pretty simple, pretty straightforward case. And so there was a chief and member of council. They were actually long-standing elected officials. I think they've been in power for pushing about 20 years. For the majority of that time, they had applied for a license to sell on-reserve tobacco. And at the time, the regulation said that an individual had to have it in their name. So the license to sell on-reserve tobacco was issued in the name of the chief. And all during that period of time, while he was an elected official, the revenue coming from the sale of the tobacco, the profit, was going directly to the community. It was just a revenue source. And it was actually quite a bit of money. I think it was like $150,000 a year, but it was a small community, so that was actually a large portion of their budget and their discretionary spending. And then, again, sometimes, unfortunately, when the chief and the council were elected out of office, they kept that revenue. And in fact, they used to sell the tobacco through a community store, and when they got elected out official, they just simply started selling it literally out of their house. But they kept all of that revenue for themselves. And so then they got sued over it. And so the court just asked some very simple questions. Did they owe a fiduciary duty? Absolutely. Did they breach the duty? Absolutely. Did the council consent to them? Didn't consent to them having the license. And part of the reasons why the council didn't consent, they didn't share all of the information with council. They couldn't make an informed decision. So again, emphasize, again, black and white. Court says here, no doubt they had fiduciary duties here. That's the easy answer. In order to get consent from the community or from the chief and council, they actually have to provide full disclosure, because if somebody's making a decision, because in theory, the community could have granted the license and allowed them to run the store and keep the revenue, or at least a portion of the revenue. So that was theoretically possible. And that's what they were trying to argue here. Like it wasn't the black and white rule that they couldn't run the store and sell the tobacco. But the court's coming back and saying, no, you have to provide full disclosure, and it has to be an informed decision by, in this situation, it would have been by the band council. So what happened to them? All of the profits had to go back to the community. They were actually held liable personally. That chief and that council member were actually held liable personally to the tune of about $150,000 a year, which is not insignificant, obviously. So next topic here is, how do you deal with employment contracts between a council member or former council member and getting an employment contract? So in this situation, it's a small community. They only had one chief and two council members. And so they had been voted out of office, but they were still exercising the authority of council. And so what did they do? They sat down and they took turns. 2 members at a time awarded a 5-year employment contract to one person who didn't, quote unquote, participate in the decision making. And so then they get sued. It ended up being more of a labor issue than a governance issue. But at the end of the day, there was a decision to say, okay, fine, did this group individually breach their fiduciary duty? And their defense was, maybe not too surprising, well, I didn't participate in the decision making. I stepped out of the room when the other 2 folks decided my contract. Then I went back into the room, somebody else left the room, we decided his contract. Then the 3rd person left the room, and the other one came back and they decided the 3rd person's contract. But the end result is what they came back and the court said, well, yes, you breached your fiduciary duties. So just leaving the room, yes, that's a requirement. That's a procedural requirement, but it doesn't give the person protection. Because what had happened here, as a group, they were, I'll use the expression, technical legal expression, scratching each other's back. You vote for me, I'll vote for you. So they did that 3 times. That's still a breach of their fiduciary duty. Because at that point in time, by giving themselves an employment contract, they are getting a financial benefit. Red flag, financial benefit. So then they have to do, well, can we make that decision? And with a small group like this, because there's only 3 members, I would have to say they did not have the ability legally to award themselves employment contracts. Because if there's 3 contracts going out and you got 3 members of council and 3 people are walking off with contracts, it's a little bit too much of a scratch my back and I'll scratch yours kind of scenario. Now, if there had been 1 contract being awarded and the two other members had debated it and made the decision and properly passed a resolution awarding that contract, it probably would be acceptable. But if the one person is getting a contract, they can't participate, and they basically can't influence the other ones to give them that contract. There's a comment here. So this is, the court talks about the importance of following proper procedure. But simply going through the motions and following proper procedure is not somehow a get-out-of-jail-free card. So it says here, and this is how strong he's saying, their practice ridiculed the procedural safeguard, which is, in the words of what judges will do and say, that is really, really strong criticism coming from a judge. That's a real strong criticism of the actions that they took to try and award themselves contracts. What happens if somebody breaches their duty by awarding money to somebody else? This is just a third party. And what I mean by that is a council member makes a decision and there's no money going directly into their pocket, but somebody else is benefiting. So this chief did a couple of things, caused checks to be issued to the tune of $149,000 to a third party, and also caused, I think it was about $10,000 to be paid to the chief from the social services department. Now this is a larger, more complex and community. They actually had bylaws and rules of conduct that actually governed the spending limit of the chief. So in this situation, the chief actually had a $500 spending limit. So when he starts, there was a series of checks from the social services department and a series of checks that went out to this third party. Every check by itself had breached his spending authority. So that is what we call prima facie a breach of fiduciary duty. And what we mean by that is that there's enough evidence, unless it's rebutted, there's enough evidence to show that this person had breached their fiduciary duty. So, and that's potentially significant in practice in the context that if there's what we call a prima facie breach and there's a lack of evidence to rebut that, the member of council is going to be liable. And I've seen, a lot of paperwork and a lot of missing paperwork from communities over the years. So sometimes there is a lack of evidence. So somebody will say, oh yeah, council had authorized me to take that contract or to pay that money. Go find the minutes. Good luck. Go find the band council resolution. Good luck. If they're not there, that means they really don't exist. So that prima facie breach can affect the ultimate liability. Again, the court tells us, how to fulfill your duties honestly, faithfully, and act in the best interest of the community. So what happened here? Punchline. Although he got no money, didn't benefit, he's paying $149,000 out of his pocket back to the community. Not because, I think if you read between the lines, there was some kind of bizarre relation between the chief and this third party. But as a finding of fact, the chief didn't benefit from that $149,000. Not a penny went into his pocket. But because he acted beyond his authority, because he breached his fiduciary duty, he had to take $149,000 out of his pocket and pay it back to the community. And the roughly $14,000 he got from the social services department, he had to pay back that too. And this kind of touches upon one of the questions asked earlier on. What happens if chief and council are going to go to the employees and tell them what to do? This is exactly what this chief did. He went to the check writing people and said, here, spend $149,000 to this corporation. Went to the social services department and said, here, issue me a whole bunch of checks for $14,000. And for most employees, when they're talking to the chief, who's got the courage to look the chief in the eye and say, no, you can't do that. Go to hell. Get out of here. Nobody's got the courage to do that. So if the chief crosses that line and goes to an employee and tells them what to do, more often than not, they're going to do it. But it can also lead to liability. As a chief or a council member, it could lead to a liability. Because most employees, they fear for the jobs. They fear if they don't do what they're told by a chief or elected official, by a council member, they fear their jobs are in jeopardy. They're going to do what they're told, even when they know it's wrong. Then there's going to be liability potentially on the elected official. How do you reconcile your fiduciary duties with gaining an honoraria? Most elected officials get some kind of honoraria or salary. Very common. And that's perfectly fine. For most elected officials, there's already been a past practice. It might even be a prior bylaw or a council resolution or even a community resolution indicating that as an elected official, you're going to get paid an honoraria, whether or not it's on a monthly basis, on an annual basis, effectively like a salary, or whether or not it's based upon how many meetings you attend or how many committees you sit on and stuff like that. Whatever the measuring stick is about how somebody's paid, if that's already in place, that is absolutely perfectly fine. And it might be that council has to adjust it periodically. Again, if it's consistent with past practice, there's going to be nothing wrong with that. But it's easy to cross the line. So in this case, a more recent case from 2015, in this situation, this was a small community, and they didn't have very much money. So everybody agreed objectively that the elected officials weren't getting paid enough honoraria. I think they were getting paid $350 a month. So from an objective point of view, that wasn't adequate compensation for the work they had put into it. In the past, maybe not so much this council, but the council in the past had asked to increase it. And Bannon administration came back and said, we can't afford it. It stayed at $350 because they can't afford it. So then they got a settlement of $125,000, fairly minor settlement because of some road access issues. So this was new money. It wasn't ongoing, it was just a one-time payment. And they decided, the four members, the chief and four members of council, the five of them, decided, well, let's pay ourselves a one-time payment of $5,000. So out of $125,000 that was going to the community, they authorized $5,000, 20% of that. There were some allegations that it was done secretly, but I think it was just, maybe bad bookkeeping, bad paperwork and the like and stuff like that. Eventually it came to light, and eventually somebody brought a lawsuit against them. And again, simple rules here by the court. You can't act in a conflict. So they're voting themselves $5,000 each. Again, red flag, financial benefit to individual members. No profit. They are clearly profiting. They're making the decision as a group. Clearly they're in a conflict of interest. So again, these are red flags. And my point is, when you see this red flag, start asking yourself, what do you do about these issues? There's a small community. They didn't have anything in writing. They didn't have procedures, didn't have a procedural bylaw, or anything else like it. It was all custom-based. So their argument was, well, we historically get paid honoraria. Historically, we revisit the payment of honoraria. So this is just us making a decision as band council to revisit and increase the honoraria as a one-time payment. And the court looked at that and said, no, that's not acceptable because that wasn't consistent with past practice. So this is one situation where there's a prima facie conflict of interest. They had a financial benefit. They voted themselves to give them that financial benefit and a conflict of interest. So that's a prima facie breach. If the analysis and the evidence stops at that point in time, they're liable. But what it does, it shifts the burden over to the members of council to put forward evidence that that breach was justified. That the conflict, for example, was waived, or it was otherwise reasonable. Maybe there's a history of giving one-time payments like that. But the evidence shifts to them to convince the court that it's otherwise reasonable. And if they can't honor that shift, if they can't prove it, then they're liable. So the court comes back, that they have to account for any benefit or gain, and the money must be repaid to the First Nation. And this was I think, probably 2 or 3 years after they actually received the money, they were required to pay that money back to the community, pay the $5,000 each back to the community. So two lessons coming out of this. Yes, payment of honoraria is perfectly fine. Nothing wrong with that, especially if it's historical practice. But red flags start going up if you start tinkering with it, especially if you're increasing it, especially if it's a one-time payment, especially if it's coming out of settlement monies. All of those are red flags that should start asking questions. So I skipped a few cases, but the cases that I skipped, they're all within this summary here anyways. But to kind of summarize all of these points that I was talking about here, without a doubt, chief and counselor fiduciaries, they have to fulfill their duties honestly, faithfully, and always act in the best interest of the community. They can't allow their own personal interest to conflict with the duty they have to the community. And what is their personal interest might change a little bit when it's extended to family members, immediate family members or extended family members. If it's a small community and if the conflict is addressed in some other way, there might be a little bit of flexibility on that. If they're that fiduciary, they're clearly in a position of trust to the community as a whole, to the assets, and to the members of the band. So the example where the folks had authorized themselves, a special payment of $5,000 worth of honoraria, that takes on special significance because that was settlement money, and they were dipping into the settlement money and distributing the settlement money to themselves rather than distributing it to the community. And like in the big picture of things, $5,000 each or $125,000 doesn't sound like an awful lot of money. But for a small community, again, keep in mind there was only 3 elected officials. That tells you how small the community was. That $125,000 could actually make a difference to that community. They have to manage the band assets in the best interests of the community, and might actually even have an obligation. And this kind of touches back to the question about the band meeting. Might have an obligation to conduct meaningful consultation with the membership. So having a community meeting, a band meeting, where, like I say, it's rushed or it's limited notice or it's poor turnout, that might not be meaningful consultation if you're looking to avoid a potential breach of fiduciary duties. Custom, again, whether or not it's unwritten, past practice, or something in writing, something as formal as a code of conduct or an election code or a governance code, can help kind of define the scope of fiduciary duties, either to expand it or to maybe contract it a little bit. So the one case I gave an example of chief only had spending authority of $500. That's a pretty clear black and white line, what authority the chief has and what authority the chief doesn't. And if the chief exceeds his or her authority, there's what we call a prima facie breach of the fiduciary duty. That would include, payment of honoraria. Again, when you talk about best practices is that honoraria is going to be very transparent and very open. The community is going to know about it, or it might even be a decision made by the community itself. Some practices, what you put in practice, again, red flag. If as an individual you're benefiting financially, or a direct family member is benefiting, or even potentially an extended family member, that's a red flag. It doesn't mean that you're actually in conflict. It doesn't mean that you're breaching your duty, but should start to cause you to ask some questions to make sure that you fulfill your duties. Don't participate in discussions, and that means not even attend. You can't attend a meeting and convey your message by body language. Make full disclosure. And if you're actually getting a payment as a fiduciary duty, that has to be what's called express authority. So again, if a council member is going to enter into a contract with the community, that contract should be authorized by the other council members at a duly convened meeting, without participation by that specific council member. I glossed over it a little bit, but conflicts in a small community, the test for bias may be relaxed in a small community because of all of the close family relationships. The line between what is an actual or potential conflict of interest and no conflict of interest may depend upon the size of the community and some of the documents in the past practice and the past history, including custom. But the rules, they're not going to be relaxed when you're actually getting a direct personal benefit. Those rules will only potentially be relaxed a little bit when you're talking about a benefit that goes to a family member or an extended family member. And to kind of finish up here, liable regardless of whether or not you did it with the best of intentions. You know, liable regardless of whether or not you actually financially benefited from it. And good faith is not a defense to this. Bad faith can make it worse. You know, we talked about the case where the chief basically burned all the bridges she could on the way out. You know, that's bad faith. That might increase liability. But on the other hand, good faith does not reduce liability. Do we call it a morning then, I guess? You're certainly welcome to approach me at lunchtime or any kind of break and stuff like that if you want to ask any more questions. But thank you for your time. Thank you for your great questions. I do appreciate the questions because sometimes it makes me think on my feet, but it also kind of gives me some indication what's weighing on your minds so that the next time I do a presentation like this, I can modify it to address your questions. So thank you very much, everybody.